Hey y'all, Van Lufa here. We're back in business. My guests are gone. Now I can film again down here. Okay, let me just say it's day 11, and I am watching and recapping the Derek Chauvin trial so you don't have to. First of all, before we get started on day 11, what is Van's scrub of the day? It is a pink scrub with all kinds of fun little things like donut worry, I love you a latte, fries before guys, something about pizza, something about we're getting pizza. Anyway, I love this script top. I get lots and lots of compliments on it at work. The kids love it. So anyway, that's neither here nor there. Let's get started. Okay, or I forgot to say cheers. Okay, day 11 of the Derek Chauvin trial was Monday, April 12th, 2021. They started out with some motions here today. Nelson, the motion was Nelson wanted to exclude the testimony of Seth Stoughton due to it being cumulative. People have already testified. It would be the sixth or seventh opinion on the use of force. He plans to walk through the video again step by step, discussing what has already been discussed. Nelson was given a supplemental report on Friday evening he found irrelevant. The court has already given the state plenty of latitude. I agree. They've already had Sergeant Steiger, who is an expert witness. And obviously the state opposed that motion. They opposed because they said that Mr. Stoughton takes an academic approach to use of force. And in the end, he ended up testifying. And then here is the big one. Oh, wait, no. That will be last. The other one was just talking about Maurice Hall. He was the gentleman that was in the car with Mr. Floyd and his drug dealer. They talked about him leaving Minnesota after the incident and fleeing to Texas, where he was apprehended and gave statements with a lawyer present. The state does not plan on giving him immunity. So he was going to testify in this case, but he knew that certain statements that he made at that time could incriminate him, and his lawyer even said that he could be facing a third-degree murder charge, so that he didn't want to testify. He wanted to, what is called, invoke his Fifth Amendment privilege. Again, the state does not plan on giving him immunity. They were going to call the agent to the stand who took his statements. He denied giving Floyd drugs that day. The judge said he will take it all under advisement and rule on it after lunch. Here was the big one. Eric Nelson made a motion to sequester the jury in light of the officer-involved shooting Sunday and the civil unrest that followed. Apparently one of the jurors is from that town. He stated that this shows the jury that a verdict does have consequences, and Nelson thinks that jurors should be asked if they heard anything about it or what impact it had on their ability to make a decision. The state obviously opposed to that motion. He does not think that they should be asked about it, and the judge ultimately ended up denying the motion for sequestration. Okay, state's witness number 34 was Dr. Jonathan Rich. He is a cardiologist at Northwestern University Hospital in Chicago. This is his first trial. He talked about his education. He's a cardiologist, but he also specialized in heart failure and heart transplantation. He discussed what his roles are. He was not compensated up until the trial. So all the hours that he put in reviewing all of the information and all of that he was not compensated for. But then he said he needed to be compensated when the time came for the trial, just to pay him for his time. And he gets compensated at $1,200 per day as long as he is there. We're in the wrong business, folks. He gave his opinion on the cause of death. He stated it was cardiopulmonary arrest due to low oxygen levels induced by prone restraint, and that he was subjected to by the police officers. Other possible factors were considered, such as fentanyl overdose and primary heart event, but neither explained his death. He viewed his medical records and the autopsy report. He stated that in his medical records, anytime Mr. Floyd had seen a doctor, whether it be in the doctor's office or in the hospital, that he never complained of chest pain. There was never a diagnosis of heart disease when he was alive. There were no abnormalities noted in the medical records. His EKGs that he had had in the past showed no abnormal heart rhythms. He watched lots of the videos. He gave a little explanation of what the chest wall is. He made his observations of Floyd, throughout the incident. He saw no distress when they were getting him out of the car. Then he talked about when they restrained him on the ground. They restrained him in a life-threatening manner. He described what he saw. He talked about PEA and asystole. Remember, PEA is pulseless electrical activity of the heart. He explained that PEA is basically a chaotic heart rhythm, but that there's still no pulse. He stated that if you can find the cause of it and reverse it, that can be reversed. He said one cause of PEA is hypoxia or low oxygen. Talked about asystole is also called flatline. He looked at the autopsy first, then the medical records, then the autopsy again. He said the heart looks normal. He also explained that coronary artery disease is not that unusual. A lot of people have it. It's very common. And that there was no evidence of a heart attack. And so he thought that coronary artery disease was excluded as a cause for his death. No evidence of heart attack in the past. Also, he explained that even if there was a heart attack in the past, there would still be evidence of that based on there being scar tissue in the heart. He was able to exclude any occlusions that he had from causing death. Drugs did not cause the death because he explained that he had a pretty low amount of drugs in his system and he had a high tolerance. So he did not see any evidence of overdose. And he believes that his life could have been saved. And then they took a mid-morning recess. He talked about the Maurice Hall ruling, stating that Mr. Hall is willing to answer things that won't incriminate him, but he doesn't want to talk about his involvement with Mr. Floyd that day. Other witnesses can testify other witnesses can testify these things about Mr. Floyd. And so they said that the questions, the statements that he made to the police officer in Texas were not going to be admissible. State's witness number 35, I hope I say this right, is Philanese Floyd, George's brother. He lives in Houston, Texas. He talked about his life. I wondered if this was the spark of life witness. I know I've explained it in the past, but a spark of life witness in a trial is somebody who gets on the stand and talks about them, talks about the person that they used to be. Basically, their job is to humanize the person, humanize the deceased. So he talked about their siblings and his parents. He loved sports. They showed a picture of Mr. Floyd and his mother when he was a child. They talked about his role in the family. Mr. Floyd was the big brother and how he was kind of the big brother in the community as well. Talked about his education. They showed a picture of him in high school. They showed a picture of him on a basketball team. Mr. Floyd also taught them football. Then they showed a picture of Mr. Floyd with his daughter Gianna, who is now 7 years old. They talked about his relationship with his mother. He's a mama's boy. Floyd taught his younger siblings how to respect their mother. Then they talked about his mother's funeral. She passed away 5/30 of 18. And his brother said that was at their mother's funeral was the last time that he saw him alive, but that they spoke on the phone a lot. Obviously, there was no cross-examination by Mr. Nelson. State's witness number 36, Steph Soughton. He's an associate professor at South Carolina School of Law. He is a professor in criminal law and criminal justice. He's been doing that for 7 years. He conducts research of the regulations of policing. They talked about his education. Prior to going law school, he was a police officer with the Tallahassee Police Department. He talked about his education into becoming a police officer. Talked about different assignments he had there at the police department. He did it for just a hair under 5 years. After that, he was an investigator in the Department of Education, and then he graduated from law school in 2011. He has published articles. He has authored chapters in textbooks. He published a book entitled Evaluating Police Uses of Force. He provides consultation to different police agencies, and he lectures throughout the country. He has been retained as an expert witness around 60 times. Sorry, had to sneeze. Okay, so he has been retained as an expert witness around 60 times. He has testified about a dozen times in court. He was retained for this case. He charges for his time. He charges $295 an hour. To date, he has received $24,000 to $25,000 payment from the state of Minnesota. He estimated to have about 130 to 140 hours on this case. He has not always reached a conclusion that favors the party who hired him. The reason being, he said his credibility is important to him. And they asked him, has he developed opinions in this case? Yes. He described the process of getting his findings in this case, how he went about that. He completed a report. It was almost 300 pages. He uses the national standards to do this, the standard of reasonableness. He also uses the Graham versus Connor factors. Then they show a copy of his use of force evaluation. His opinion was he didn't feel that putting him in prone position was appropriate. They showed clips of the video, and he broke down what was happening in all of his opinions. So this was the motion that Eric Nelson didn't want to happen, but it happened, where they showed video clips over and over, and he broke down every little thing. And then they took a 20-minute break, because of course they did. More questioning of Mr. Stoughton. And it was at this point I wrote in my notes, I had a hard time listening. He is saying the same thing over and over. And it's just the way he talks. Oh, just annoyed me. On cross-examination, Eric Nelson was just talking about how you have to take the totality of the circumstances into consideration. Yes. He questioned what he used for his analysis. He asked, do officers rely on past experience? Yes. People don't like to be arrested, and sometimes they feign illness to get out of it. And then he gave some crazy answer here. So Mr. Stoughton was not a yes or no man. He would have to give a long story or explanation, speak very fast, and make himself look really uber smart before at the end he'd finally say, well, then yes. It was very annoying to me. And I find this dude to be slimy. He wants to argue and just come off as glib. So Mr. Nelson said, according to your analysis, it was unreasonable for them to put Floyd in a prone position, correct? Yes. He didn't present a threat, is what he said. And then Mr. Nelson said, reasonable minds can disagree, right? No. Did you hear the testimony of Sergeant Steiger? It was his assessment it was reasonable to put him in that position at that time. And Mr. Stoughton said, well, I disagree with him. Stoughton said, prone position is only a transitory position, only to handcuff or get control. Here was the interesting part. So Mr. Nelson said, okay, so it's only you just said it's only a transitory position, only to handcuff or get control. Yes. Then Nelson uses an article that Stoughton himself wrote about sometimes needing to be held in that position. So basically he asked him how he felt and then used his own article against him. He also noted that article was written 4 days after the incident in 2020, and that it seems that he had already made up his opinion before reviewing the case. They just did more questioning. He asked, when you're doing your use of force analysis, you aren't doing it in a dangerous situation, I assume? No. You have the luxury of slow motion, enhancements, looking at things from multiple perspectives. Agreed, and he said yes. On redirect, they again discussed proportional force. They discussed situational awareness and paying attention to what is right in front of you. The state lawyer said, if you have situational awareness, wouldn't you recognize that you are kneeling on a limp person? Yes. Wouldn't a reasonable officer listen to another officer when the other officer says a pulse can't be found? And he said yes. But mind you, he didn't always just say yes. He had to give, a 2-minute answer and go around in circles and all of that. I didn't even, I listened to it all, but I just simply couldn't write everything down because I was just too annoyed. Okay, so that wrapped up the day. I have a question. On Friday, Dr. Andrew Baker was questioned by the state, right? When they were finishing in the afternoon on Friday, he said, you know what, we're not going to get through cross-examination today. It would be way past 5. We're just going to have you come back on Monday and do it then. Where was Dr. Andrew Baker today? He was nowhere to be found. And from what I watched, I don't believe it was addressed. So I'm waiting for somebody to tell me. Okay, so the important things that Judge Cahill said after we were done today was this. The defense's case starts tomorrow. All evidence should be given by the end of the week with possibly Friday off. He doesn't want closing arguments on Friday because as soon as they go to deliberation, they are sequestered. And he doesn't want them to finish closing arguments on Friday and then have them be sequestered all weekend. So they hope that all the evidence is by the end of the week and that they can start their closing arguments on Monday, and he told them to pack a bag. And that is all I have for you. Today was a little harder to listen to only because I did not care for that witness. But anyway, that's all we have. So here we go. The defense is going to start presenting tomorrow. I am super interested to see what they have to say. So anyway, that's all I have for you tonight. Thank you guys so much for watching, and I'll see you on the next one. Bye.